My name is Alan Levy. I'm a community schemes attorney for 20 years now. We situate in Waverley in Johannesburg. Today's training is an introduction only. You're invited for further events which will be scheduled, where we'll go into more depth and spend some more time on each aspect of the Popia and the Paia and the pack that we've provided to your schemes. So please stay tuned for those further training sessions. The Popia and the Paia Acts together are 10 times the size of the Sectional Title Schemes Management Act, the STSMA. They're complex and they're interlinked, as well as attracting criminal sanctions and fines, unlike the STSMA. Please do not expect to leave today's training understanding everything. This will only be achieved after all the training sessions and ordering and implementing the Popia packs. Even after this, we are going to be faced with many questions in the industry, which we will work through and provide answers to. I personally have put in over 500 hours in the last 6 months, analyzing the Popia and the Paia and preparing the packs, and we've only just begun. Governments and the new Office of the Information Regulator are scrambling. They have just repealed and re-promulgated new Paia regulations, which are currently open for public comment. Stick with us and stay learning, and we will ensure compliance by all parties concerned. We're going to spend approximately until 11:50 this morning, so 50 minutes together. In the future sessions, we can possibly spend some more time together. If your schemes don't yet have the Popia compliance pack or a Paia pack, please make contact with your portfolio manager. We will also shortly have the managing agents pack ready and packs for landlords. So if any of your departments manage rental portfolios for landlords, you also need a landlord's pack, which you can contact our office for. Key to the Popia and the Paia endeavor is communication to all owners turned by the Popia data subjects and compliance. One has to have all the documentation in place and apply the contents when processing and providing personal information of a data subject. If a scheme purchases our pack, they will get the following. They get a Popia manual called a Popia Compliance Framework. They get a compulsory Popia addendum to the managing agent's agreements. They get these PowerPoint presentations explaining the Popia and Paia. They receive scheduled Zoom training on Popia and Paia. They also receive a circular to all owners explaining Popia and Paia, a Popia non-disclosure agreements template. We'll explain that in the slides to come. A Popia WhatsApp group security message. We'll also explain that in the slides to come. And access to a Popia and a Paia hotline or email for selected assistance. Please also remember us for all your other legal requirements. We specialize in community schemes and also conveyancing, collections, evictions, and property and family law. Please lastly note that the slides and the Popia pack are copyrighted and may not be copied or distributed at all. They can only be used by the scheme making use and who's ordered the pack. If you find today's training useful, please take a few minutes and give us a Google review or a Facebook review. Without further ado, let's proceed with today's presentation. At the bottom right, left-hand side in white, you'll see Part 1, Introduction, Popia and Paia. Community Schemes and the Popia, Protection of Personal Information Act, and Paia, Promotion of Access to Information Act. What is the Popia? On the right-hand side, we've just given you the preamble. Just want to move something out the way. We've just given you the preamble to the Act, but on the left-hand side in the yellow, the Popia commences on 30 June 2021 It's been introduced to better protect people's personal information. The scheme or the managing agent has to identify what personal information is being held. The personal information can then only be processed in accordance with the 8 conditions set out in the Popia. One of these conditions is the sending of a notification to owners, tenants, etc., notifying them what personal information, or PI, you have of theirs and of their rights. Each scheme must have a Popia manual or a compliance framework describing how it will comply. In charge of this procedure is the chairman of the scheme, who the Popia by default nominates as the information officer. He has various responsibilities set out in the Popia and the regulations. He also has to conduct what's called a PIA, a personal information impact assessment. We'll turn to that in part 3, and I'll take you through how that's done. These assessments analyze how the personal information is being processed and must develop mechanisms to ensure the protection of personal information. So that's just a little bit about the Popia. Moving on to the PIA. On the right, again, the preamble to the Act. On the left, the PIA has commenced, and from 30 June, community schemes have to publish their PIA manuals. The PIA has been introduced to better enable the constitutional right of access to information. The manual must describe the records that the scheme holds and how these records are accessed. And it must also describe various details in regards to the Popia. The manual attaches a form to be completed by a person requesting access to records and sets out the fees that a requester must pay. The manual must be published on the scheme's website if it has one and be kept at the place of business of the scheme. The manual must also refer to the guide, which will be published by the information regulator. So please don't confuse the guide with the manual. The PIA manual is the scheme's manual. The guide is the one national document that the information regulator will publish. So the manual must refer to the guide, which will be published by the information regulator, the new government body charged with monitoring and enforcing compliance with Popia and Paia. All right, terms used in the Popia. Data subject, it's a person to whom the personal information relates. Owner, tenant, trustee, employee, contractor. Responsible party, that's the scheme, BC or HOA or share block. Operator is Wakefields, the person processing the personal information for the body corporates. Information officer, by default the chairman. Personal information, ID number, telephone number, biometrics, private correspondence, CCTV, etc. There's a host of personal information that the scheme and managing agent will have. Processing, we'll look at that in detail just now. The activities defined in the Popia, collecting the personal information, collating, retrieving, and disseminating. Terms used in the PIA, we have the head of a private body, which is also the chairman. So the chairman is the head of the private body in terms of PIA, and he's the information officer in terms of Popia. Private body is a juristic person, the body corporate or HOA or share block. A record is recorded information regardless of the form in the possession of the private body. Requester is a person making a request for access to a record. So please familiarize yourself with all these terms, which the acts are full of. All right, the current status of each act. The Popia commenced on 1 July 2020, almost a year ago. But in terms of section 114, all processing must conform to the Popia by 30 June 2021. So we have about 40 working days for all processing to conform. The PIA commenced almost 20 years ago. Community schemes are exempted from compiling the manual until 30 June 2021. There's been amendments to the PIA per the Popia, which amendments are effective 30 June 2021. Because of these amendments, there's certain changes which have to take place to the PIA manual, which we'll also discuss, and which Wakefields will be in touch with its schemes about. There's also been amendments to the Paia regulations. They're in process. The closing date for public comment is 17 May 2021. So government is scrambling and leaving a few items to the last minute. They've just repealed the Paia regulations and re-promulgated them. They're open for public comment. We will discuss that in detail just now. All right, what documents each act requires you to have? For Popia, you must have a compliance framework. You must have an addendum to the managing agent's agreement. For Paia, you must have a manual. So altogether, 3 documents are necessary. Summary of the Popia. The Popia introduces 8 conditions to process information. Data subjects have a host of rights set out in Section 5 and Section 18. One of the main conditions are security measures which must be taken to secure the integrity and confidentiality of the data subjects' personal information. The Popia introduces the Office of the Information Regulator. That's the government department who has to educate on processing personal information, or PI, monitor and enforce compliance with Popia and resolve complaints. Each community scheme must have an information officer who has the duties set out in Section 55 and Regulation 4. In about 20 minutes time in part 5, we will look at all the details about an information officer, which each scheme must have. All right, summary of the Paia. The Paia compels the information regulator to publish a guide containing information required by a person to exercise a right in terms of the Popia or a Paia. Again, this is not the complex's manual. This is a national guide which the regulator will publish. A requester must be given access to a record if it is required to exercise or protect a right, if the procedural requirements of the Paia are followed, and if access is not refused in terms of Section 62 or 70 of the Paia. We'll look at the Paia in detail in the parts to come. Each scheme must have a manual describing the records it holds, and in regards to Popia, the purpose of the processing, the categories of data subjects, like owners, tenants, employees, the categories of recipients, owners, bondholders, anyone who wants information, and a summary of the security measures which have been implemented. A requester must complete the Form C. He must pay the request fee, if any, a deposit if required, and an access fee, and must be notified within 30 days if his request is granted or not. The request can be refused if it involves an unreasonable disclosure of PI about a third party, and must not be refused if stipulated conditions exist. So that is a summary of the Paia and the Paia manual. All right, Popia and Paia are very much integrated. On the left-hand side, through Popia, data subjects' PI is better protected and rights are afforded to the data subject in regards to their PI. Through Paia, records can be requested and access to information through the Paia process is encouraged as a constitutional right. So Popia protects the information and Paia encourages access to the information, and the two are very much integrated and work together. Types of community schemes. On the left, body corporates, as set out in the Popia, the consent of data subjects is not required to process their personal information. So for body corporates, we do not need data subject consent, since the Sectional Title Schemes Management Act and Prescribed Management Rule 27 legislates the processing. So because we're relying on a legislative obligation, we don't need data subject, owners, tenants' consent to process their information. HOAs and share blocks are somewhat different. The processing is less prescribed by law. HOAs have no dedicated act. We recommend that HOAs and share blocks amend their governance documentation, and they can prescribe the processing of information, for example, in their rules, in order that consent from data subjects to the processing is less required in most instances. So they can pass a rule that owner's consent to processing of their personal information. That way it becomes somewhat of a law, and data subjects consent in HRAs and share blocks will then not be required to process personal information. All right, and that is part one, which is the introduction. We're now going to move swiftly to part two, which is the POPI compliance framework. For those scheme executives that are present today and that have ordered their POPI pack, page 1 to approximately 17 is your POPI compliance framework. It's everything you need to become POPI compliant. So we're going to spend a few minutes just going through POPI and what we call the PCF, POPI compliance framework. All right, what is the POPI compliance framework? The POPI compliance framework is a written document all about the processing of personal information that the information officer has a responsibility to develop. Well, we've developed it for you, but he has a responsibility to further develop it. He has to implement it, he has to monitor it, and he has to maintain it. Your scheme's PCF, POPI compliance framework, has been provided to you. You and your information officer must develop, implement, etc. That's all contained in POPI Regulation 41A. An information officer must ensure that a POPI compliance framework is developed, implemented, etc. All right, what personal information does the scheme have that the POPI compliance framework relates to? On the right-hand side, I've given you some summaries and definitions. A data subject, that's an owner, a tenant, an employee, a scheme executive, contractor. Personal information, some examples are race, marital status, email address, biometrics, personal opinions, correspondence, CCTV. Processing, it's the operation concerning personal information, including collecting the personal information, recording it, organizing it, disseminating it, etc. So on the left-hand side, we say that the POPI and the POPI compliance framework relate to the processing. Those are all those items of personal information. Those are all these items that the scheme holds of data subjects. Those are all these people. Such as owners, tenants, trustees, employees, agents, contractors, and bondholders. And then we say personal information in the case of sectional title. Schemes includes, but is not limited to, all the prescribed Management Rule 27 documentation. In the case of homeowners associations, the documentation will be similar. Examples of ID numbers, addresses, etc. So that's the personal information that the scheme and the POPI compliance framework relates to. All right, this is a very important aspect of POPI. It takes up about 20 sections in the POPI Act. And what are the 8 POPI conditions to process personal information? Condition 1 is a summary, accountability. POPI obligates the scheme, not the managing agent, to ensure the conditions are complied with, all 8 of them. Processing limitation. The personal information which the scheme has must be processed in a manner which does not infringe on the data subject's privacy. And they only be processed if the data subject consents. The processing is necessary for performance in terms of a contract or is in compliance with a legislative obligation. So with sectional title, we have a legislative obligation. There are other exceptions in section 11 of the POPI. The personal information must also be collected from the data subject directly, unless it's derived from public records, or the data subject has consented, or collection from another source would not prejudice the data subject. See section 12 for other exceptions. Condition number 3. Purpose specification. The scheme can only collect personal information for a lawful purpose related to its function or activities. Personal information cannot be retained longer than necessary unless required contractually or by law or consented to, and thereafter must be destroyed or de-identified. That is the third condition. Condition 4, further processing limitation. If the scheme is going to further process personal information, it must be for a lawful purpose. Information quality. The scheme must take reasonably practical steps to ensure that the personal information is accurate and updated. Openness. The scheme must maintain the documentation of all processing operations under its responsibility. The scheme must make data subjects aware of the information being collected and the source, the recipients of the information, and of their right to lodge a complaint to the information regulator. It is not necessary to comply with the above if non-compliance is necessary because legal proceedings are being conducted. If you've handed over an owner to an attorney, you don't have to make the data subject aware because that is required for legal proceedings. But otherwise, you've got to make data subjects aware of the fact that information is being collected in terms of Section 18. And in our pack are templates for notifying the data subjects of this and all the other rights. 2 more conditions to go. Condition number 7, security safeguard. This is the most important condition. This condition is one of the reasons why the Paia Act was amended. The amendments take effect from 30 June 2021. This condition now also has to go into the Paia manual. Let's read about it. The scheme must take appropriate and reasonable technical and organizational measures to secure the integrity and confidentiality of the personal information, to prevent loss, damage, and unlawful access. So each scheme and the managing agency needs technical and organizational measures, whether it's for the physical documents, lock-up cupboards, and for the online cloud or server documents, protection for cyber fraud, email fraud, hacking, and all these things which are becoming more and more common in the world and in South Africa. So the scheme must take all these measures. The scheme must identify the risks, establish safeguards, and update the safeguards for new risks, taking into account security practices in its industry. The managing agent to process the information must have the authority of the scheme, Section 20. We'll touch on that again just now. The scheme must have a written contract with the managing agent, ensuring the security measures are established and maintained. If an unauthorized person has accessed information, the managing agent must notify the scheme, and the scheme must notify the information regulator. We'll touch on all of those relationships just now again. But certainly this is the most important of the 8 copy conditions. The last condition, subject participation. The data subject, free of charge, can request of the scheme whether it holds its personal information, what it holds, and who has accessed it. So if I'm an owner in your complex, for free I can ask you, what information have you got of mine, and who has accessed my information? Again, in the template we've given you, there's documents to record all of this information. The scheme can refuse such request in terms of the Paia. So by me asking doesn't necessarily mean the scheme will say yes and give me the documents. A data subject can request the scheme to correct or delete inaccurate, out of date, or information obtained unlawfully. That's also dealt with in the pack. The scheme must notify the data subject of the results of the request. That's also detailed in the pack. Those are the 8 copy conditions. Let's talk a little bit about the necessity for a POPI conduct rule. For body corporates, a conduct rule is not really necessary. It doesn't hurt, but not as necessary as for HOAs and share blocks. For body corporates, to justify the processing of information, body corporates rely on Section 11(1)(c) of the POPI. That processing complies with an obligation imposed by law. In this case, it's the STSMA and PMR 26(2) and 7. For HOAs and share blocks, they either have no dedicated acts or the relevant acts. The Share Blocks Act doesn't deal with personal information per se, and it cannot as easily be relied upon to justify the processing of personal information. So it's therefore recommended that for HOAs and share blocks, a conduct or house rule be adopted, dealing with personal information, and thereby placing the HOA and share block on an equal footing with the body corporate. The rule will basically state that owners agree and consent to the HOA processing their personal information. Once they've agreed to their rules, it becomes somewhat of a law, and then one can rely on section 11.1 of the Popia, that processing complies with an obligation imposed by law, and consent of the data subjects won't be needed. So in summary, the conduct rule is more required for HOAs and share blocks. All right, Popia non-disclosure agreement. The scheme in terms of section 19 of the Popia has a duty to prevent unlawful access to personal information. When the scheme supplies personal information to owners, bondholders, auditors, insurance companies, attorneys, security companies, computer and software companies, this must be in terms of a non-disclosure agreement signed by such party. So whenever the scheme gives out personal information, it will now be in terms of a non-disclosure agreement, which we will provide Wakefields with, so the scheme can meet its obligation and duty to prevent unlawful access to personal information in terms of section 19 of the Popia. All right, security measures. On the right-hand side, I've quoted section 19 of the Popia. As we said earlier, this is the most important of the 8 Popia conditions. We went through it already, all the security requirements that the scheme and the managing agent has to have in place. Let's have a quick look at it on the right-hand side. Again, a responsible party must secure the integrity and confidentiality of the personal information or under its control by taking appropriate, reasonable, technical and organizational measures to prevent loss, damage to or unauthorized destruction of personal information and unlawful access to or processing of personal information. In order to give effect to subsection 1, the responsible party must take reasonable measures to identify all reasonably foreseeable internal and external risks to the PI in its possession, establish and maintain appropriate safeguards against the risks, regularly verify that the safeguards are effectively implemented, ensure that the safeguards are continually updated in response to new risks or deficiencies in previously implemented safeguards. The responsible party, which is the scheme, must take due regard to generally accepted information security practices and procedures which may apply to generally or be required in terms of specific industry or professional rules and regulations. That is the most important of the Popia conditions, section 19, security measures. And on the left-hand side, the scheme must sign an addendum to the management agreements with the managing agent to ensure that the managing agent establishes and maintains the security measures set out in section 19 of the Popia. So in your addendum, which is an annexure to the pack we've given you, it sets out that these section 19 protocols will be implemented. All right, again, talking about the addendum to the managing agent's contract, the scheme must sign an addendum to its written agreement with the managing agent in terms of section 21 of the Popia to ensure that the managing agent establishes and maintains the security measures. Section 21 says that a written contract must be signed between the scheme and the managing agent. Right, let's talk briefly about WhatsApp groups. These have become very popular in schemes around the country. These communication and texting groups contain personal information of owners and other participators, such as names, phone numbers, and opinions. The administrator of those groups, whether the scheme or the managing agent, must preferably have each person participating consent to process, which is to receipt and store, their personal information, or post on the group regularly that by participating in the group, the participants are deemed to have consented. Each participant must undertake, or via the above post, at least be deemed to have undertaken, to not process, collect or disseminate, etc., the personal information of other persons partaking in the group. So we will also provide Wakefields with the template for these WhatsApp group posts, which can be used by each scheme or the WhatsApp groups. All right, and that is the Popia Compliance Framework, the PCF, part 2 completed. We're now going to move to part 3. Part 3 is the PIA. At the bottom left, Personal Information Impact Assessment. Don't confuse this with the PIA, the Promotion of Access to Information Act. This is the PIA. Strictly speaking, one doesn't need a written document for the PIA, but in the packs that we have given you, we've given you a template which you can use, as well as some information. So when the trustees and the information do the PIA, which they can do biannually or quarterly, they have a working document to work through. So let's have a quick look at what's required in terms of doing a PIA. Right, what is the Personal Information Impact Assessment, or the PIA? On the right-hand side, Popia Regulation 41B. The information officer must ensure that a PIA is done to ensure that adequate measures and standards exist in order to comply with the 8 conditions to process personal information. So all the information officer is doing is ensuring that measures and standards are in place. All right, on the left-hand side, the PIA is mandatory. It's designed by the trustees. We've assisted you with that in the pack. We've designed a template for you. It must be repeated when there's a significant change to the scope of the processing. I'm going to show you when it must be repeated in the next slide or two. The PIA describes the processing operation and assesses its compliance. The processing operation is, for example, Alan becomes an owner in a scheme. I give you all my personal information. The managing agent uploads it to its records, to its software. It provides them to the trustees, to other owners. That is all encompassed in the processing operation. So it has to assess its compliance. It also evaluates any risks on the fundamental rights of data subjects. What risks are there to Alan giving his information? And it identifies measures to curtail those risks. How will we bring those risks down? It provides for accountability by the scheme with Popia. That is all done in the PIA, which should be done biannually or quarterly at least. But we'll have a look the next slide or two when exactly a scheme should do a PIA. All right, when must a PIA be conducted? If there is processing of sensitive or highly personal information. So, for example, if biometrics are installed in the complex, if CCTV is installed in the complex, if there's processing on a large scale, if Wakefields is setting units off plan, or if a new phase of a scheme is being developed and 500 units are being transferred, if the scheme is implementing technological or organizational solutions, new software, if there's been a significant change to the processing operation, or if publicly accessible space is monitored on a large scale, like CCTV, then you must conduct a PIA. What must a PIA contain? A documentation of the processing activities to identify risks and mitigations. So when the trustees do a PIA, they will go through the activities around processing information. The who's and the how's and the when's of who's involved in processing information, and they will identify what the risks are and how will they mitigate and reduce those risks. A setting out of the relationships and flow of information, whether it's between the owner, the scheme, the managing agent, the information officer, the bondholders. They will set out the relationships and how the information flows between all these people. An explicit statement of how the 8 POPI processing conditions are being complied with. So every time you do a PIA, one has to look at the 8 POPI conditions and states explicitly how they're being complied with. A record of the information officer's advice, difference of opinion if some of the trustees disagree with him, and it must be signed off by the trustees. And an agreement to a schedule of reviewing the PIA. So one can agree that every 4th month or 4th trustees meeting, the PIA will be reviewed. That's what a PIA must contain. What internal measures or systems must be developed? We're going to look on the side now. This is also part of the PIA, Regulation 41D. The information officer must ensure that internal measures are developed. So he needs to develop internal measures and adequate systems to process requests for information. On the left, the information officer must ensure that the measures or systems set out in the Popia and Paia are developed together with adequate systems to process requests for information. The PCF and Paia manual contain these measures or systems to assist the information officer with this obligation. So in the template you ordered from us, we've given you a page for Popia Regulation 41D for these internal measures that the information officer must develop. The next regulation is 41D. The information officer must also ensure that internal awareness sessions are conducted. So the information officer is going to be a very busy guy in the months and years to come. He must ensure that internal awareness sessions are conducted. On the left, he must hold and document these sessions, and it's to raise awareness and ensure updated compliance by the scheme with the POPI. In the pack you've ordered for us, we also have an annexure to assist the information officer with conducting these internal awareness sessions. So this is all part of the PIA that the information officer and the trustees will do annually, biannually, or quarterly. All right, and that is the end of the section on the PIA. We're now going to move to part 4, which is the Promotion of Access to Information Act, the PIA and the PIA manual. Most of the Wakefield's complexes already have PIA manuals, but as I've said before, the POPI has amended the PIA Act and what the PIA manual has to contain. Furthermore, the legislature, as I said, is now scrambling, and they've repealed the PIA regulations and they've repromulgated them. They're open for public comment. So those regulations also, once passed, will have an impact on what the PIA manual must contain. So in the weeks and months to come, schemes across the country who have PIA manuals will have to get advice and look at updating their PIA manuals. Let's look at what is the PIA manual. Let's start on the right-hand side, section 51.1 of PIA as amended. The amendment kicks in on 30 June 2021 when the POPI kicks in. The head of a private body. The head of a private body is by default the chairman. We're going to look at that in the next part. He must make a PIA manual available, describing the records available and how to access them, as well as information concerning POPI. So one of the amendments is that the PIA manual must have information about POPI. Previously, the PIA manual never needed POPI information. Regulation 41C, an information officer must ensure that a PIA manual is developed, monitored, maintained, and made available. So there are the obligations to have a PIA manual made available. On the left, it's a written document which each scheme must have drafted and which the trustees must maintain. It's not a static document. The trustees have to maintain the document. Each year, each few years, the PAIA manual might have to be amended. It describes the records the body corporate has available and how one gets access to the records, as well as information about the Popia and the security measures that the scheme has put in place. That all now goes in the PAIA manual. Some of that will not be in old PAIA manuals because the Popia has amended the PAIA Act, and PAIA manuals now have to have new information. All right, legislation applicable to the PAIA manual, the Promotion of Access to Information Act, PAIA, obviously. As per the above, the Popia amended the PAIA, which amendments are effective 30 June 2021. The PAIA regulations were on 23 April, last week, repealed and re-promulgated. The new regulations are open for public comments until 17 May. So you've got about 2.5 weeks if you want to comment on the regulations. If you want a copy, you can just pop me an email. What goes in the PAIA manual? It's really quite simple. The scheme's contact details, an introduction setting up the legislative aim of the manual, a description of the guide to be made available by the information regulator. Again, don't confuse this with the scheme's manual. This is the national guide, the one guide that the regulator will publish. You've got to describe the guide in the scheme's manual. Description of the records that the scheme holds, all the community scheme records, the minutes, and the emails, and the contracts and the plans, all the labor legislation records, employment contracts, pay slips, tax records, etc. These must all be described. Sorry, if everybody can just put themselves on mute, that will help. All right, what else goes in the PAIA manual? Sufficient information to facilitate a request for access to information. So there's a whole paragraph dealing with how somebody gets access to information. Information in regards to Popia, including the security measures. That's a recent addition to the PAIA manual. You've also got to say that the manual is available for inspection at the place of business of the scheme. So the managing agent will have the manual available at its premises. And if the scheme has a website, the manual must also go on the scheme's website. So that all goes in the PAIA manual. All right, fees to be paid by the requester and request form. If a requester wants to request a document from the scheme, does he pay for it? The old PAIA regulations published a table of fees for private bodies, such as schemes. The new draft regulations don't contain an amended table. So we're just going to have to look into why the amended table hasn't been published. Are they intending that the old table of fees be applicable? The request form, Form C, published by the legislature, is used by a requester to request access to a record. So Form C is a very nice, understandable form that a requester completes to get a record from the scheme. Right, how a request for access to a record works in terms of PAIA. The requester completes Form C and emails it to the head of the scheme. So if an owner, tenant, bondholder wants information from the scheme, they've got to complete Form C, PAIA Form C, and they're going to email it to the head of the scheme, which is the information officer. Sufficient detail must be provided by the requester to enable the head of the scheme to identify the record. We've got to know what exact record the requester wants, and the requester, who the requester is, and the right sought to exercise. What rights is the requester seeking to exercise? The requester must also explain why the record is required to protect the relevant rights. Okay, Form C is also a very nice form, and it gives you sections where all this information can be inserted. The requester must pay the request fee to the scheme before further processing takes place. the scheme in certain scenarios can also request a deposit for certain preparation. Scheme can say to the owner, we're not going to process your request until you pay a deposit. Once he pays the deposit, we search and prepare the record and supply it to the data subjects, i.e. the owner. What happens next is the head of the scheme, the information officer, if he wants, the trustees or the managing agent can help him, he considers the request in terms of the file, and he may refuse it in terms of section 62 to section 69. These sections contain multiple reasons on which a request can be refused. So the head of the scheme might refuse the request. Also, the record may not be able to be found. The head of the scheme must notify the requester by way of affidavit that the record cannot be found. The head of the scheme must advise the request of the decision to grant the request or not within 30 days. So if the owner requests information today, by 30 May, he must be informed of a thumbs up or a thumbs down. It is also possible to ask for an extension of 30 more days in terms of the act. All right, and that is the end of the Paia and the Paia manual. We've covered 4 parts already. We're going to spend the next part covering information officers. So information officers by default are the chairman of each scheme. The chairman is the information officer for the Popia, and he's the head of the body corporate for the Paia. Automatically, one has to register your information officer with the information regulator. I'm going to talk you through how to do that now. Your information officer can also authorize any other person to be the information officer. It's got to be someone at executive or management level at the managing agent, or it can be the auditor or an attorney. And I'm going to take you through how all of that works now. And then we'll stop. We might have time for 1 or 2 questions, but I do have to finish at about 11:55 or so, because I have another session at midday today. All right, who is the information officer? Just like I said now, by default, he's the chairman. He can also authorize any other person to be the information officer, and it's quite easy. I'm going to show you in the next slide or 2. Legislative references. Popia sets out the duties of the information officer, section 55. Popia, regulation 4, his responsibilities. And Paia, proposed new regulation 3, this is the one that's open for public comment, his obligations. So we have information officer's duties, responsibilities, and obligations. So after seeing all of this, you may not want to be the information officer. Information officer's duties, section 55 of Popia. He has to encourage compliance by the scheme with the 8 conditions to lawfully process information. He must deal with requests made by data subjects. He must work with the information regulator, and he must ensure the scheme complies with the Popia. Those are his duties. His responsibilities, regulation 4 of the Popia. He must ensure a Popia compliance framework is developed. He must ensure a personal information impact assessment to peer is done. He must ensure a Paia manual is developed. He must ensure internal measures are developed. And he must ensure internal awareness sessions are conducted. Those are his responsibilities. We've covered all of those already in the previous parts, and all of those parts are in the pack that we've provided for you, except for the Paia, because the Wakefield's complex is already in the Paia manual. Let's look at the duties, or rather the obligations, in terms of the new Paia Regulation 3. The information officer is obligated to cause the guide published by the information regulator. Again, this is the one national guide that will be published in all the languages. He must cause it to be made available on its website in each of the official languages. So if the scheme has a website, the website must have the guide published in all the official languages. So once we obtain that from the regulator, we will give it to Wakefield, and that guide can go on all of these schemes' websites. You must also cause the guide in at least 2 official languages to be open for inspection at its offices. Wakefield will have the guide published by the regulator in at least 2 languages available for inspection at Wakefield's offices, which is also the scheme's offices, so to speak. All right, registering your information officer. Very easy. On the left, you go to our website, you go to the Downloads tab, you scroll down to Popia and Paia right at the bottom, and you download the first form. You complete the form, and you have the information officer sign it. Remember, if you're a body corporate, in terms of Management Rule 10, 2 trustees have to sign all documents, and there's got to be a trustee's resolution. So a second trustee must also sign, and there must be a resolution if you're a body corporate. You then email the form to this address. Your information officer is then registered, and he can commence his duties. On the right is just the front page of the form. The form in total is 5 pages, and it's quite easy to complete. The information regulators also released a guidance note. The guidance note is 17 pages. It looks like the picture on the right-hand side. You also go to our website, download Popia and Paia, and you download the second document to read the guidance note. Please use Annexure C to the guidance note for the chairman to authorize an alternative person as the information officer. If the chairman can't be the information officer, it's too risky, he doesn't have enough knowledge of the processing operations, he doesn't have enough time, he can authorize another trustee, an auditor, an accountant, an owner, someone from the managing agent to be the information officer. Again, if you're a body corporate, remember to have a second trustee sign the authorization and to have a trustee's resolution. Offences by information officers. These are all the reasons not to be an information officer. Section 90 of the PIA, if you intentionally deny a right of access by destroying, damaging, altering, this will be the most common, concealing or falsifying a record. It's a criminal offence. So if the information officer conceals a record, or in terms of section 93, he willfully or grossly negligently fails to comply with section 51 of the PIA by making a PIA manual available. If a scheme doesn't have a PIA manual and he's been grossly negligent, these are both offences, and they carry a fine or imprisonment not exceeding 2 years. So those are reasons not to be the information officer. Further information from the guidance note, please download it from our website. These are 4 very important points. 1, a person authorized as an information officer should be at an executive or management level. So not everybody can be an information officer. He must be at executive, director, or management level. 2, the chairman remains accountable and responsible for the powers and functions of the authorized person. So the chairman is still accountable. 3, despite authorizing another person, the chairman can still exercise the powers or perform the duties. So the chairman can still perform. 4, the authorization can be withdrawn or amended. So those are all on the guidance notes with other points. So it is useful to download and read. All right, and that ends the 5 parts of today's presentation. Just to read you the first paragraph of the disclaimer. This presentation is meant as an introduction only and does not include the full details and requirements of the Popia and Paia. For all the necessary details and requirements, the Popia and Paia compliance pack must be ordered by the scheme from Allen Levy attorneys. And of course, you must please, when we release further training, in more detail, attend the training. The last slide is just a summary of the other departments that our firm specializes in. There is a minute or two for one or two questions. You're welcome to pop that in the chat